Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, in today's video we are going to discuss the preliminary exam paper of Andhra Pradesh Judicial Services 2020. I hope कि ये videos आपके लिए बड़ी useful रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही बेनिफिशियल रहेगा. एंड अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel, and while subscribing don't forget to press the bell icon so that you can get the notification of our upcoming videos. And अगर आपको हमारे efforts अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. आप जो है. So let's move on to the questions. Question number 1 is: the court shall have jurisdiction to try all suits of civil nature excepting suits of which they are either expressly or impliedly barred. 1 would be the answer. This is mentioned in section 9 of CPC. Next is 2. Under CPC, in every plaint, fact shall be proved by evidences या hearing affidavit or examination. Affidavit. 3 is the answer. And where this is mentioned? It is mentioned in section 26 subsection 2 of CPC. Next is 3. Which of the following allows transfer of decree under CPC? The transfer of decree is mentioned in section 39. Yes, it is. So 1 is the answer. 36 is application to orders. Okay. 23. To what courts application applies? 62 is seizure of property in dwelling house. Next is 4. Which of the following properties cannot be subject to attachment and sale in execution of decree under section 60? Wages of labor cannot be attached, mentioned in section 60 subsection 1 and proviso clause H. Okay. Motor car is a movable property, additional house, immovable property, jewelry, movable property, so they all can be attached and sold. All right. Next is 5. Under section 89 of CPC, for settlement of disputes outside the court, which of the following method is not available? Arbitration, mediation, conciliation is there. Mini trial is not there, so 1 is the answer. Next 6. Under section 115 of CPC, the court can call for record of any case from High Court, Lok Adalat, tribunals. Who can? Which court can? Section 115 is revision. How? Reference, review and revision. 113, 114 and 115. So revision की power किसके पास है? Who has the power? High Court. 2 is the answer. Next is 7. Under CPC, where it appears to the court that any joinder of plaintiff may dash or dash the trial of the suit, the court may put plaintiff to their election or order, make such other order as may be expedient. Embarrass or delay. 3 is the answer. Plaintiff may embarrass or delay the trial. The court may put to their election order. Okay. So 3 is the answer. Next is 8. A person entitled to more than one relief in respect of the same cause of action may sue for all or any of such reliefs, but if he omits except with the leave of the court to sue for all such relief, he can sue such relief anytime? No. Fresh suit? No. Can sue? No. He shall not afterwards sue for any relief, so omitted. Order 2, rule 2. है ना? So 4 is the answer. Next is 9. With reference to CRPC, 1973, complaint means any allegation made orally or in writing with a view to his taking action under this code that some person, whether known or unknown, has committed an offense. So किसको करेंगे? Orally in writing to a police officer or magistrate? Magistrate. 4 is the answer. Section is section 2D, definitions in CRPC. Now section has been changed, obviously. It has become now section 2H. Okay, in भारतीय नागरिक सुरक्षा संहिता. Next is 10. according to section 25A of CRPC, a person shall be eligible to be appointed as director of prosecution only if he has been practiced as an advocate for at least not less than 10 years. 2 is the answer. Section 25 is mentioned here. Now in Bharatiya Nagrik Suraksha Sanhita, the 10-year has been made as 15 years of practice or session judge. Okay. Next is 11. D.K. Basu vs. State of West Bengal is a leading case on rights of arrested person. 1 is the answer. Next is 12. Under section 105F of CRPC as amended, the court may appoint dash to perform the function of administrator of seized or fortified property. Local person no, law expert no, district collector no, district magistrate. ये होते तो सेम ही है पर्सन दोनों, बट वो मैजिस्ट्रेट वर्ड यूज किया जाता है फॉर CRPC. That's why 4 is the answer. Now the section has become section 117 in Bharatiya Nagrik Suraksha Sanhita. Next is 13. In which of the following case Supreme Court allowed grant of maintenance under section 125 CRPC to a woman engaged in a live-in relationship? देखिए रिपीट क्वेश्चन है, ये आंध्रा में ही पूछ चुके हैं. विमला वर्सेस वीरास्वामी नो, सविता बेन नो, चनमुनिया वर्सेस वीरेंद्र कुमार कुशवाहा. 3 is the answer. This is 14. With reference to CRPC as amended, select the correct pairing of section and the subject. Section 164, recording of confession and statement. This is correct. So first is correct, so 1 is the answer. Now this section has become section 183 in BNSS. Section 161 has now become 180, 155, 175, 166, 186. The power to hold investigation or preliminary inquiry. This is section 159. Police officer's power to investigate cognizable case 156 में है ये, and search by police officer 165 है. So therefore these two are wrong. Next is 14. A is accused of theft of a gold ring at a certain place, at a certain time and place. As per section 213 of the CRPC, the charge should set out the manner, need not to set out the manner in which theft was effected. 2 is the answer. This is illustration A in section 213. Now the section has become section 236 in BNSS. Next 16. With reference to section 460-61, in which of the following case the proceeding shall be void if the magistrate not being empowered by law does it. और देखिए 460 है, the proceedings do not vitiate 460, and which vitiate is 461. Now the section has become 506 and 507. However, the clauses are same, so we will write here 460 and 461, 506, 507. Okay. Issue a warrant under section 94 mentioned in clause A. This would not vitiate. Tender a pardon clause G. It would not vitiate. Makes an order of maintenance. This would vitiate. Mentioned in 461 clause G. Hold an inquest under section 176C. Okay, so which one would vitiate? Makes an order of maintenance. 3 is the answer. Now section 94 has become 97, 306 has become 343 in Bharatiya Nagrik Suraksha Sanhita. Okay. Next 17. According to section 63 of IPC, where no sum is expressed to which a fine may extend, the amount of fine to which the offender is liable is reasonable, not limited, unlimited. It is unlimited but not excessive. 3 is the answer mentioned in section 63 itself. And now this has become section 8 in Bharatiya Nyaya Sanhita. Next is 18. Section 269 deals with the offense relating to See, adulteration of food is in section 272. Fraudulent use of false weights and measures 265. Negligent act likely to spread infection of disease dangerous to life is 269. So 3 is the answer. Prohibition of fictitious stamp is 263A. Now section has been changed. Adulteration of food is 274. This 269 has become 271 and 263A is 186 in Bharatiya Nyaya Sanhita. Next is 19. With reference to section 299 and 300, culpable homicide and murder. Now this is 100 and 101 in Bharatiya Nyaya Sanhita. Select the incorrect statement from the option below. Culpable homicide is genus and murder is species. Yes, this is correct. All murder is culpable homicide, but all culpable homicide is not murder. This is correct. IPC practically recognized 3 degrees of culpable homicides. This is also correct. There is no distinction between culpable homicide and murder. No, this is wrong. So 4 is the answer. There is distinction. That's why the section has been differentiated. Next is 20. A incites a dog to spring upon Z without Z consent. Here, if A intend to cause injury, fear, or annoyance to Z with reference to IPC, what offense, if any, A has committed? This is use of criminal force. So 3 is the answer. Act endangering life or personal safety of others is section 336. Assault 351. Criminal force 350. Hurt is 319 in IPC. And this is illustration H in 350. Now section has been changed. This 336 has become 125. Assault 130, criminal force 129, hurt 114 in Bharatiya Nyaya Sanhita. Next is 21. Offense related to acid attack have been inserted in IPC wide section dash in the year dash. देखिए, section of acid attack came by the amendment of 2013 and section was 326A and 326B. So 2 is the answer. Now the section has become section 124 in Bharatiya Nyaya Sanhita. This 354C is voyeurism. This has become 77. 354B is assault with intent to disrobe. This has become now 76. And this is 354D stalking. This is now 78. Next 22. Which section of IPC has been declared unconstitutional by Supreme Court of India in Joseph Shine vs Union of India? That was related to adultery and section was 497. So 2 is the answer. Next 23. Counterfeiting of currency notes or bank notes is punishable with which of the following section of IPC? This is section 489A. 4 is the answer. Now this section has become 181 in Bharatiya Nyaya Sanhita. Next 24. According to section 499, that is defamation. Which of the following act amounts to defamation? Imputation in form of an alternative or expressed ironically. Yes, this is defamation. Express of opinion in good faith. No. Good faith. Public good require. No. Wherever something good is mentioned, that is not defamation. So 1 is the answer. And section 499 has become section 356 in Bharatiya Nyaya Sanhita. Next is 25. With reference to Indian Evidence Act, admissions are not conclusive proof of the matters admitted, but they may operate as estoppels. So 2 is the answer. Mentioned in section 31 of Indian Evidence Act. Now the section has become section 25 in Bharatiya Sakshya Adhiniyam. Next 26. Dying declaration is made under section of Indian Evidence Act. 32(1) everybody knows. Repeat question, common question. 1 is the answer. Now DD has become in section 26 of Bharatiya Sakshya Adhiniyam. Next 27. The question is whether a certain document was written by X. Another document is produced which is proved or admitted to have been written by X. Which of the following is relevant under the Indian Evidence Act? The opinion of expert on the question whether the two documents were written by the same person or different person are relevant. This is correct. Opinion of concerned person, no. Witness, no. Expert ka opinion is required. So 1 is the answer. Mentioned in section 45 and this is illustration C. Okay. Now section 45 has become 39 in Bharatiya Sakshya Adhiniyam. Next 28. Under section 56 of Indian Evidence Act, no effect of which the court will take judicial notice need to be proved. So 3 is the answer. Now the section has become 51 in Bharatiya Sakshya Adhiniyam. Next 29. Under section 60 of Indian Evidence Act, oral evidence must in all cases whatever be dash, that is to say it refer to a fact which could be seen. It must be evidence of witness who say he saw it. Be direct. 1 is the answer. Now section 60 has become section 54 in Bharatiya Sakshya Adhiniyam. Next is 30. With reference to Indian Evidence Act, read the following statement A and B and select correct option. All persons authorized to take evidence are included within the meaning of the court. This is correct. Mentioned in interpretation section 3 of Indian Evidence Act. Arbitrators are covered within the meaning of court. No, this is wrong. Okay, mentioned the definition of court in interpretation section 3 itself. So A is correct, B is incorrect. 3 is the answer. Now section 3 obviously has been changed. The definitions is now mentioned in section 2 and the definition of court is mentioned in section 2A of Bharatiya Sakshya Adhiniyam. Next 31. With reference to Indian Evidence Act, fact which though not in issue are so connected with the fact in issue as to form part of the same transaction are relevant whether they occurred at the same time or same place or different time or place. This rule is known as res gestae. Everybody knows, very common question, repeated question. 4 is the answer, mentioned in section 6 of Indian Evidence Act. Now this is section 4 in Bharatiya Sakshya Adhiniyam. Next 32. With reference to Indian Evidence Act, select the correct statement from the options below. Examiner of electronic record is not an expert in criminal proceedings. The fact that the person is of a good character is not relevant. Both are wrong. Expert is mentioned in section 45 of Evidence Act and this statement 2 is section 53. All facts except the content of electronic record may be proved by oral evidence. This is mentioned in section 59 of Evidence Act. So this is correct. The content of document may be proved by primary evidence only, no primary or secondary evidence. This is wrong. So 3 is the answer. Now section has been changed. Obviously this has become 39 and this all facts is now section 59 has become section 54 in Bharatiya Sakshya Adhiniyam. Next 33. Which of the following section of Indian Evidence Act raises conclusive proof of legitimacy of child born during marriage? This is section 112. 3 is the answer. And अब ये हो गया है section 116 in Bharatiya Sakshya Adhiniyam. Next 34. With reference to Indian Evidence Act, select the incorrect statement from the below. Judge and magistrate cannot be compelled to answer any question as to his own conduct. This is correct. Mentioned in section 121. Communication during marriage cannot be permitted to be disclosed. This is also correct. Section 122. Official communication made in official confidence cannot be disclosed. This is also correct. Mentioned in section 124. Then fourth is assumption from disclosure of privileged communication made to lawyers, barristers or pleaders do not extend to clerk or servants of the barrister or lawyers. This is wrong. It also extends to them. And this is mentioned in section 127 of Evidence Act. So 4 is the answer. 4 is incorrect. Now section has been changed. Obviously 121 has become 127. Then 122 is 128. This is 130. And this is 132 subsection 3. Okay, in Bharatiya Sakshya Adhiniyam. Next 35. With reference to Indian Evidence Act, any question suggesting the answer which the person is wishes or expects to receive is called a leading question. 4.2 is the answer. This is mentioned section 141 of Evidence Act. A section has been changed. 141 has become 146 in Bharatiya Sakshya Adhiniyam. Next 36. In which of the following case the Supreme Court reiterates that the evidence of hostile witness could not be completely effaced? The same requires corroboration and strict scrutiny. The case was S. Arul Raja versus State of Tamil Nadu. 4 is the answer. Next 37. According to Indian Contract Act, A proposes by letter to sell a house to B at a certain price. The communication of proposal is complete when A posts the letter, no. B receives the letter, yes. When A sends the letter to B and B receives the letter, the proposal is complete. Okay. And when B accepts the letter and posts it, then acceptance is complete. So 2 is the answer, and this is illustration A in section 4, communication of proposal and acceptances. Okay. Next 38. Which of the following is not a method of revocation of proposal under Indian Contract Act? By the communication notice of revocation by the proposer to the other party, this is a method. By lapse of time, yes. By refusal of acceptor, this is not a method. By failure of acceptor to fulfill a condition precedent to acceptance. So 3 is the answer. This is mentioned in section 6 of Contract Act. Next 39. A contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in the position to dash the will of the other. Dominate, influence, change, effect. Dominate the will. 1 is the answer. Mentioned in section 16 of Contract Act. Next is 40. A agrees to buy from B a Alsatian dog. It turns out a dog was dead at the time of bargain. Though neither party was aware of the fact, the agreement is void. When both parties are at mistake, so the agreement would be void. 2 is the answer. You can see illustration B of section 20 of Contract Act. Next 41. A agrees with B to discover treasure by magic. The agreement is void because it is uncertain event, unlawful. It is an agreement to do an impossible act. 3 is the answer. You can see illustration A in section 56 of Contract Act. Next is 42. Under section 5 of Specific Relief Act, a person entitled to possession of specific immovable property may recover it in a manner provided by CPC. Very common question, repeat question. So 3 is the answer. Section is already mentioned here. Next is 43. Which of the following does not fall into contract not specifically enforceable under section 14? Means they are asking the contract which is enforceable. So party has substituted performance of contract. So this cannot be enforceable by specific performance. Okay. Then involve the performance of continuous duty which the court cannot supervise. This is also not enforceable. So dependent on the personal qualification of the parties cannot be enforced. Contract has been entered into without lawful consideration. When there is no consideration, it is void agreement. Okay. So 4 is the answer. Next 44. When through fraud or a mutual dash of the parties, a contract or other instrument in writing does not express their real intention, it may be rectified under Specific Relief Act. Mutual mistake. 1 is the answer. This is mentioned in section 26 of SRA. Next 45, preventive relief is granted under SRA as a matter of right, obligation at the discretion of the court. 3 is the answer mentioned in section 36 of SRA. Next is 46, temporary or perpetual injunctions under Specific Relief Act are regulated by CPC. 2 is the answer. Section is 37. How it is regulated? By order 39. Temporary injunctions, isn't that? Next 47. Under the Hindu Marriage Act, where a decree for judicial separation has been passed, it shall no longer be obligatory for the petitioner dash to live with the respondent or to consummate the marriage or not to rescind the respondent, to cohabit with the respondent. It includes living plus consummation. This is the wordings of section 10. Alright. So 4 is the answer. Next is 48. Divorce by mutual consent is provided in which section of the Hindu Marriage Act? That is section 13B. Everybody knows. It is very common question. So 4 is the answer. 13A is alternative relief. Means if you are going for a divorce decree, the court may pass judicial separation. Alright. Section 11 is void marriage. 9 is RCR. Next is 49. One person is said to be agnate of another if two are related by blood or adoption wholly through males. 1 is the answer. If not wholly through males or it is written through females, then it is cognates. Mentioned in section 3A agnate and 3C cognate in Hindu Succession Act. Next is 50. Which of the following has not been added in section 6 by Hindu Succession Amendment Act 2005? Daughter of a co-partner shall by birth become a co-partner in her own right in the same manner as the son. It is correct. Surviving son or daughters and the mother of the intestate shall take each one share. This is true, but it is not mentioned in section 6. Okay. If this is incorrect according to section 6, that doesn't mean the statement is incorrect. Statement is correct, but not in section 6. Daughter has the same right of co-partnership property as she would have had if she had been a son. This is correct. Be subject to same liabilities in respect of the same co-partnership property as that of a son. Yes. If you get the asset, you will also be liable for that with the liabilities. So 2 is the answer, not added by section 6. Next 51. Any property possessed by a female under Hindu Succession Act, whether acquired before or after the commencement of the act, shall be held by her as a full owner. 1 is the answer. Very common question. And where this is mentioned in section 14 of Hindu Succession Act. Next is 52. The chance of heir apparent succeeding to an estate cannot be transferred under section 6 of TPA. It is mentioned in section 6. So 4 is the answer. Very common question. Repeat question. Next 53. Under TPA, where property is transferred subject to a condition or limitation absolutely restraining the transferee or any person claiming under him from parting with or disposing of his interest in the property, the condition or limitation is void. 2 is the answer. Where this is mentioned, it is mentioned in section 10. Oh, that is conditions restraining alienation. Next 54. Section 13 of TPA makes provision for transfer for benefit of unborn person. So 1 is the answer. Rule against perpetuity, section 14. Conditional transfer, 25. Oral transfer, section 9. Next 55. A transfer rupees 50,000 to his daughter C if she will desert her husband. The transfer is void under TPA as per section 23 or 25. 25. Conditional transfer. The condition is void. 3 is the answer. And you can see illustration D for this. Next 56. Under TPA, a vested interest is not defeated by dash of the transferee before he obtains possession. By the act, death, condition of will, by the death of the transferee. 2 is the answer. It is mentioned in section 19. Next 57. Under Registration Act, a registered document shall operate from a time from which it would have commenced to operate if no registration thereof had been acquired or made. 1 is the answer. Time of registration, it is from the time of execution. If you want to say simply, from the date of execution. This is called as doctrine of relation back. Okay, it relates back to the time of execution. And the section is 47 of Registration Act. Next 58. As per Negotiable Instrument Act, a check is a bill of exchange drawn on specified banker. Very repeated question, common question. Check is mentioned in section 6 of NI Act. 3 is the answer. Promissory note is 4. Bill of exchange is 5. Negotiable instrument 13. Inchoate instrument section 20 in NI Act. Next 59. As per NI Act, as amended, every promissory note or bill of exchange which is not expressed to be payable on demand at sight or presentation is at maturity on the dash after the day on which it is expressed to be payable. 3rd day, 2nd day, 5th day, 7th day. On 3rd day, 1 is the answer. And where this is mentioned? In section 22. It is called as day of grace. Next 60. Magistrate have to record reason before converting trial of complaint under section 138 from summary trial to summons trial under the second proviso of section 143. This was held by court in which of the following case? So a very famous case in the expeditious trial of cases under section 138 NI Act. 2 is the answer. Next 61. With reference to Negotiable Instrument Act, when a promissory note or bill of exchange has been dishonored by non-acceptance or non-payment, the holder may within a reasonable time cause such dishonor to be noted and certified by the notary public. Such certificate is called as, it is protest. 2 is the answer. Mentioned in section 100. Noting is mentioned in section 99. Notice and of protest is section 102. Endorsement is 15 in NI Act. Next 62. With reference to section 147, every offense under NI Act is compoundable. 3 is the answer. Mentioned in section 147 itself. It is mentioned here. Next 63. As per NI Act, court trying an offense under section 138 may order the drawer of the check to pay interim compensation which shall not exceed 20% of the amount of check. 4 is the answer. So a new amendment mentioned in section 143A of NI Act. Next 64. According to JJ Act, a child in conflict with law means a child who is alleged or found to have committed offense and who has not completed 18 years of age on the date of commission of offense. 3 is the answer. So repeat question. How many times I'm going to tell you about this? Everybody knows. Child in conflict with law. It is mentioned definition section 2 clause 13. Okay. Next 65. Which section of Juvenile Justice Act enumerates general principle to be followed in the administration of the Act? This is section 3 itself. 1 is the answer. Section 5 is placement of person who ceases to be a child during inquiry. Okay. 6 is placement of a person who committed an offense below 18 years of age. 10 is apprehension of child to be in conflict with law. Okay. Next 66. As per Juvenile Justice Act as amended, power to issue adoption order has been conferred on district magistrate. 2 is the answer. Earlier it was court. This was amended by the Amendment Act of 2021 with effect from 9 August 2021. Means at that time in paper of 2021 they asked about the recent amendments. Any recent amendment has coming in any of the acts which has been asked in this question paper, kindly go through that. There will be one question on that. Next 67. With reference to Juvenile Justice Act, select the correct statement. The registration of a child care institution is optional. No. State government shall establish child welfare committee at state level. It is central government. No sentence of death or life imprisonment can be passed against child in conflict with law. This is correct. Mentioned in section 21. Abater of offence shall get lesser punishment than the provided for the offence. This is also wrong. So 3 is the answer. Next 68. Under section 2J of Limitation Act, period of limitation means the period limitation for any suit, appeal or application by the schedule. So 1 is the answer. Next 69. The period of limitation against a carrier for compensation for losing or injuring goods under Limitation Act is dash on a date of injury or loss occur. It is 3 years. 3 is the answer, and this is mentioned in Article 10 of Schedule of Limitation Act. Next is 70. The period of limitation by a mortgager to redeem or recover possession of immovable property mortgage is 30 years from the day dash when the transfer is effected, या फिर when the transfer becomes known to the plaintiff, when the mortgagor re-enters, या फिर when the right to redeem or recover possession accrues. 4 is the answer. And this is mentioned in Article 61A of Schedule of Limitation Act. Next 71. Under Limitation Act, the period of limitation for compensation for a malicious prosecution is 1 year. 1 is the answer, mentioned in Article 74 of Schedule of Limitation Act. Next 72. Under Section 2B of Limitation Act, application includes a petition. Only this is mentioned in Section 2B. 3 is the answer. Next 73. Under Indian Easement Act, an easement is a right which the owner or occupier of a certain land possesses and as such for the dash of the land. Beneficial enjoyment. 2 is the answer. Again, this is a repeat question. This is mentioned in Section 4 of Easement Act. Next is 74. Under the Indian Easement Act, the dominant owner cannot, by merely altering or adding the dominant heritage, substantially increase the easement or reduce or after or change an easement. Increase an easement. 1 is the answer. This is mentioned in Section 29 of Easement Act. Next 75. Extension of useless easement is provided in Section 42 of Easement Act. 2 is the answer. 43 क्या है? What is 43? Extinction of permanent change in dominant heritage. Okay. 32 is right to enjoy without disturbance. Section 12 of Easement Act is who may acquire easement. Okay. Next 76. Under the Indian Stamp Act, settlement means any testamentary disposition in writing of movable or immovable property made for all of the following purposes except for consideration of marriage, no; distributing property, no; religious purpose, no; for settling business transactions. 4 is the answer. The definition of settlement, where it's provided in Section 224 of Indian Stamp Act. And the purpose, consideration for marriage, is mentioned in 224 in clause A, this is B, and this is clause C. So they are asking except means not included in the purposes. So settling business transaction. Okay. Next 77. According to Section 4 of Indian Stamp Act, where in the case of any sale, mortgage settlement or several instruments are employed for completing the transaction, dash shall be chargeable with duty prescribed. All the instrument या फिर principal instrument only. 2 is the answer. Section is mentioned already. Next 78. All instruments chargeable with duty and executed by any person in India shall be dash stamped before a time of execution. Yes, it is time of execution only. No, after no, after no. So 1 is the answer mentioned in section 17 of Indian Stamp Act. Next is 79. Whether any act, omission, commission or conduct respondent constitutes domestic violence under section 3 of DV Act. So they are asking which act, perception of women shall be taken into consideration, gravity, behavior, overall fact and circumstances. This is a repeat question. So 4 is the answer. This is mentioned in section 3 explanation 2. Okay. Next is 80. If the protection officer fails to discharge his duties as directed by magistrate in the protection order without sufficient cause, he shall be punished with imprisonment which may extend up to 1 year. 2 is the answer, and there also will be fine of 20,000 rupees. Mentioned in section 33 of DV Act. Next 81. With reference to the protection of women from domestic violence, appeal against order of magistrate to court of session can be filed within 30 days on date of which the order is served on the aggrieved person or respondent. So 2 is the answer mentioned in section 29 of DV Act. Next 82. With reference to protection of women from domestic violence act, interpretation of share household in SR Batra versus Tarun Batra in 2007 is not correct interpretation and the said judgment was not laid down correct law. This was overruled. This case Tarun Batra was overruled in which case? In Satish Chandra Ahuja versus Sneha Ahuja. 1 is the answer. Next is 83. Section 12 of AP Excise Act as amended is what? Appointment of Commissioner of Prohibition Excise. This is section 3. Export of intoxicant section 10. Import is 9. Permit of transport of intoxicant is section 12. So 4 is the answer. Next 84. Section 37A of AP Excise Act deals with penalty for adulteration resulting into death. 3 is the answer. Penalty for adulteration is 37. Penalty for misconduct of license 36. Penalty for consumption in chemist shop is 38. Next 85. Under section 20 of AP Excise Act, district magistrate can order closure of shop in which intoxicant is sold for prevention of crime, encouraging prohibition, for preservation of public peace. 4 is the answer. ये सब तो होते ही होते हैं. Option 4 is particularly mentioned in section 20. So 4 is the answer. Next 86. With reference to AP Excise Act as amended, select the incorrect statement from the options below. Intoxicant cannot be imported without permit. This is correct. There is requirement for permit, है ना? Buying under section 2(4) includes gift. This is also correct. Section is mentioned. Arak includes Indian made foreign liquor. No, this is wrong. Arak is defined in section 2(1). They always ask a question on Arak. Okay. Intoxicant includes Gulmohar. This is correct. So 3 is the answer. Next is 87. Online gaming has been included in the definition of gaming under AP Gaming Act 1974 as amended in the year in 2020. 2 is the answer. The definition of gaming is provided in section 2(2) of AP Gaming Act. Next is 88. Penalty for gaming or setting birds or animals to fight in public street or public can be imposed under section 9 of AP Gaming Act. 2 is the answer. Section 8 is instrument of gaming found in common gaming house. Okay. And in section 9, punishment is 3 months and or fine of rupees 300. Next 10 is power to arrest without warrant. Section 4 is penalty for being found gaming in gaming house. Gaming house में अगर आप gaming करते पकड़े गए, you get caught, then punishment as per section 4. Next 89, with reference to section 3 of AP Gaming Act, the person in case of club means president, secretary, every person having care and management, person having care management of such place. 3 is the answer. Next is 90, with reference to AP Gaming Act, all instruments of gaming seized in a public place may be sold and proceed to be deposited in the government treasury, destroyed or forfeited. Destroyed or forfeited, 2 is the answer, mentioned in section 8 of AP Gaming Act. Next is 91. Collector as defined under AP Land Encroachment Act means any officer in charge of a revenue division and includes all the following except deputy collector or sub-collector, assistant collector, or additional collector. Additional collector is not mentioned in the section, so 4 is the answer, and the definition provided in section 1A subsection 1 of AP Land Encroachment Act. Next is 92. Under section 6 of AP Land Encroachment Act, any person who unauthorizedly re-enter or reoccupies a land from which he was evicted under this section shall be punished with imprisonment for a term which may extend to 6 months of a fine, 1,000 rupees. 1 is the answer, and this is mentioned in section 6 subsection 3. Next 93. Under AP Land Encroachment Act, the decision as to the rate or amount of assessment rent fee payable under section 3 shall be recorded in writing and shall not be questioned in any civil court. 3 is the answer. This is mentioned in section 3 subsection 4 of AP Land Encroachment Act. Next is 94. Under the civil rules of practice, advocate includes a lawyer, barrister, pleader, or counsel. Includes a pleader. 4 is the answer, mentioned in Rule 2 Clause B. Next 95. Interim decree under AP Civil Rules of Practice means a decree declaring dash of the several parties and providing for determination of the particular property or sum of money to be appointed or paid by any party. Declaring rights and liabilities. 1 is the answer, and this is mentioned in Rule 2I of AP Civil Rules. Next is 96. Chapter 3 of Criminal Rules of Practice deals with investigations. 1 is the answer. Summons and warrants is Chapter 2. Oaths of Affirmation, Chapter 4. Code of Session, Chapter 6. Next 97. With reference to Criminal Rules of Practice, in awarding sentence of imprisonment in default of payment of fine, regard shall have be had to gravity of offence, behavior, social status, economic status of accused. See, the imprisonment is for default of payment of fine, so economic status of accused shall be taken into consideration. 4 is the answer, mentioned in Rule 64 of AP Criminal Rules of Practice. Next 98. With reference to Criminal Rules of Practice, summons to accused shall be signed by court officer and magistrate, any person authorized. Magistrate himself. 2 is the answer, mentioned in Rule 8. Repeat question. Same question has been asked. Next 99. With reference to Criminal Rules of Practice, select the correct statement from options below. Magistrates appointed to mobile court may hold their sitting at any place he wishes. No, within their territorial jurisdiction only, mentioned in Rule 5, Subrule 2. In urgent bail application, in case of non-bailable offence, notice to prosecution is not mandatory. It is mandatory, mentioned in Rule 5, Subrule 4. In case related to juvenile offender and woman may be tried in camera. Yeah, this is correct. 3 is the answer. This is mentioned in Rule 5, Subrule 3. Rule 5 sub rule 2. Judicial work can be done on holidays also? No. Only in courthouse, and courthouse opens on working days mentioned in rule 5 sub rule 1. Next is 100. With reference to criminal rules of practice, intimation of arrest of member of parliament shall be given to, किसको देंगे? प्राइम मिनिस्टर को या प्रेसिडिंग ऑफिसर ऑफ हाउस? प्रेसिडिंग ऑफिसर ऑफ द हाउस एंड द मिनिस्ट्री ऑफ होम. 4 is the answer. This is mentioned in Rule 17 of AP Criminal Rules of Practice. So friends, here we have discussed all the questions of preliminary exam paper of Andhra Pradesh Judicial Services 2020.
अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें.
एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं फ्रॉम, तो काइंडली गिव अस अ सुपर थैंक्स.
सो फ्रेंड्स, थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.